Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. 2 days back, on 18th of August 2023, in the case of Harendra Roy versus State of Bihar, in criminal appeal number 1726 by 2015, Justice 3 Judges Bench of Supreme Court of India, Justice Sanjay Kishan Kaul, then Abhay Srinivas Voka and Vikarmanath, they have reversed the acquittal into conviction. So the appeal against acquittal was successful. They have reversed the acquittal into conviction. That too in a high profile case where the main accused is none other than RJD leader and former MP Mr. Prabhunath Singh. It's a double murder case. That too, election time, the double murder took place. So his acquittal was reversed and he was given conviction. And in this connection, the Supreme Court or Apex Court heavily criticized the deplorable conduct of the presiding officer for miscarriage of justice, the investigating officer, the PP and the trial court. They have failed miserably in performing their respective duties and responsibility. In this connection, the Apex Court commented, prosecutor has got a duty to the state. Prosecutor has got duty towards the accused. Prosecutor has got duty towards the court. The prosecutors, they are not representatives of any party. Please remember. But that is what practically happening. That's why Supreme Court has heavily criticized. How this thing happened? Now let us go to the facts of the case. This relates to crime number 62 by 95, which occurred in the month of May 95. Registered under sections initially 147, 148, 149, 307, read with IPC and section 27 of the Arms Act. Ultimately, 2 people died. Therefore, this 307 was plus 302 IPC was added. Right? So, the main accused is Mr. Prabhunath Singh. So, actually, the allegation is that he was responsible for the double murder. Singh was accused of murdering 2 persons. So, this Harendra Roy, appellant's brother, was one of the deceased. So, this Singh was accused of murdering 2 persons near a polling booth in Chapra in May 1995. Why? Because they have not voted as per his wish or to him, since they did not vote to his party. And the lower court acquitted, the high court dismissed the same acquittal is confirmed. Luckily, the matter came before the Supreme Court. One of the deceased's brother, that is Harendra Roy, he has brought it to the notice of the Supreme Court. And after going to the documentary evidence, Honorable Supreme Court called the trial shabby, investigation tainted, and it showed the present pathetic state of the criminal jurisprudence system. So it has all favored the high-handed member of the parliament, right? So in 2008, the High Court dismissed the case due to lack of evidence. So only one point I want to touch upon. Here, the mother of one of the deceased, she was supposed to give 164 statement, but she was lifted away by the members of this MP. She was not appear. She was not she was not produced in the court. 3 times the adjournment have to go. Ultimately, she has come and deposed. And the investigation, as far as the investigation is concerned, the scribe of the FIR, he was not mentioned as a witness. He was not examined as witnesses. No explanation was given as to why the police could not produce the scribe of the FIR. And the IO, most important point, IO, double murder case, the IO was not examined because of his absence. So delay due to lack of evidence, that is one of the reasons. The IO did not turn up. And the recovery mediators, they turned hostile, they were not. And as regards the PP, he filed evidence, he filed affidavits, and he also allowed 311 CRPC petitions, the re-examination of the witnesses on behalf of the defense, not on behalf of the plaintiff. So, as a result of which, the defense has got beautiful evidence, whereas the prosecution has no evidence, and therefore the case ended in acquittal. So please remember, the court said, stakeholders, maybe the IO, maybe the trial court, maybe the PP, all of them, they failed miserably to perform their duty thoroughly. The public prosecutor, the conduct of the public prosecutor is clear that he was acting for the accused. Here, Supreme Court mentioned, PP is a minister of justice. PP is a minister of justice. Though seldom we describe them, it is not his duty to secure a conviction or to see that he has to see that the innocent person is acquitted. According to 154 Law Commission report, PPs are the ministers of justice. They are not representatives of any party. But what is going on present day? Suppose if some party is in power, the advocates who are their supporters, they will get the plum posts of a PP, additional PP and others. So Supreme Court said, you are not representative of any party. It is not his duty to get a conviction. He should not strive for that. He should strive for the people. He is responsible. He has got a duty towards the accuser also. That means to say, if he is an innocent person, the PP must be able to say that there is no case against him. This is what 154th Law Commission report says. So the main job of the PP is to assist the court by placing all relevant material. They are not there to see that the culprits escape. Ultimately, Honorable Court reversed the acquittal and asked him to asked Mr. Prabhunath Mishra, who is on bail, to surrender immediately and suffer the sentence for offence under section 302 and 307 of the Indian Penal Code. So please see my video once or twice. It's not that easy to understand this language. So better you see and better you go through the judgment. Of course, judgment is a very lengthy judgment. At least you have to read the important paras, particularly the scathing comments against the PP, against the IO, and against the trial court for allowing the so-called 311 petitions. Right. So already time is 8 minutes is over. You may get bored. Thank you.